Thank you. Good
Thank you.
morning, again, everyone. Elias Thomas, Hearings Manager at ECMC. I am here to give part two of my presentation on how we're implementing SB 24-185. I gave the first portion of this presentation in September regarding provisions that went into effect in August that affect pooling applications under our rules and statute. This is part two. I'm going to provide, if we can go to the next slide, please. Um, Two things to discuss today. First, some clarification on one of the matters that I touched on in September regarding pooling of unleased local government mineral owners. We've gotten some questions about that, so I will try and clear that up and provide a bit more guidance. And then we'll discuss operating procedures for, namely, one provision of SB 24-185 that goes into effect on January 1st, 2025. Excuse my typographical error there. Um, I will note that in addition to this PowerPoint being made available, we are actually working on a full written guidance document outlining process for the entirety of SB 24-181. Hope to have that ready to go by the end of the week after I hear if there are any questions or concerns at this meeting. So with that, we can go ahead and dive in. Next slide. So first matter, protections for unleased mineral interest owners in pooling. Here's the statutory language regarding pooling unleased owners if they're a local government that has one, rejected an offer to lease, and two, the minerals subject to the interests are within the local government's geographic boundaries. Previously, my guidance here was if an application proposes to pool a local government unleased interest, we're going to deny that application pursuant to the statute. So applicants should clearly identify any local governments that are unleased mineral owners within the local government's geographic boundaries as a standalone paragraph in their application. We did not provide sufficient clarification on different scenarios, which is what I'm going to do here. So next slide. What we really want is for these to be clearly delineated in the application. So permitting review forms now include a space to note if any local government owns minerals within the unit to be pooled, and it'll identify such local governments in that review. Hearings units asks that in the case any local government unleased interest exists within the unit to be pooled, they are identified for clarity and administrative efficiency. We would like them clearly stated in the application. And although the existence of a local government unleased interests within the application lands, it's not going to be grounds to return an application or delay noticing of the application. Permitting is going to require the applicant to clearly identify and describe any local government unleased interest within the application. Um, Explicit acknowledgement of both the existence of local government-owned minerals and their exclusion from the application. Not only will it clarify the compliance with the statute, but it'll give any local government interests a clear statement of the applicant's intent as to their minerals within the application. So it's providing another line of clarity, is how we see this. A couple of other things to clear up. The statute does define local government as home rule or statutory county, city and county, or municipality. So any of those interests should be clearly identified in the pooling application submitted to us. For purposes of this process, reject will mean an active refusal by mineral owner to lease or participate. Failure to respond does not constitute rejected under SB 24-185. Any unique scenarios, obviously those will arise. Those will be addressed on a case-by-case basis. And finally, the application and materials should demonstrate that the local government has either accepted a subsequent offer to lease or is clearly no longer being pooled in the application. So any changes can be addressed in subsequent testimony or filing a corrected application if the status of a local government interest owner or whether or not the applicant has changed their mind as to including them in the application. That can be done via supplemental testimony or with a corrected application that will not require renoticing. That will not be considered a material change to the application. Next slide, please. So we'll briefly talk about the three most common scenarios that we envision and how these should look within the application. So number one, there are no government-owned minerals within the application land. All we're looking for in the application is a straightforward and simple sentence. There are no local government unleased interests within the application lands. That is sufficient to comply with the statute. Scenario two, the application lands include local government-owned minerals, but the applicant does not intend to pool those interests under the application. Again, we would like those local government-owned minerals to be clearly identified by name, and then a clear and simple statement that the applicant intends to exclude those local government-owned minerals from the application and subsequent pooling order. Next slide, please. In scenario three, the application lands contain local government-owned minerals and applicant does intend to pool those minerals with the pooling order requested. Again, we ask that you identify by name each of the local governments that own minerals within the application lands that are subject to the statute, and then clearly whether you intend to include all of them or some of them, and what we would like to see moving forward. As noted, that statement is not going to hold up the application. But we would, as this moves forward, need to see that supplemental testimony or corrected application showing that at that time, the local government has either agreed to a subsequent offer to lease or they will be excluded. And so we would need to see that in some form within the hearings file. And I believe we can go to the next slide. Once again, any changes to that will be addressed on a case-by-case basis. And we can move forward to the next issue. And just for clarification, that provision is already in effect as of August 7th. So we have been working with some applicants to get that clearly delineated in the applications. If you have any questions, you can always reach out to the hearing officer assigned to the matter or to the planning and permitting specialist assigned to the matter. Okay, moving forward, this provision is the one that we'll be discussing that goes into effect on and after January 1st, 2025. If a drilling unit contains the mineral interests of any unleased mineral interest owner that has rejected an offer to lease pursuant to subsection 7DI of this section, an operator shall not drill or extract minerals from the drilling unit before a pooling order is entered by the commission. Process-wise, again, for purposes of this process, reject means the same thing as we discussed in the previous matter. It will mean an active refusal by a mineral owner to lease or participate in the wells. Failure to respond is not a rejection. Operationally, a new submit tab comment will be added to the Form 2 process to allow operators to denote the existence of an unleased owner that has rejected an offer to lease. And next slide, please. What that means is staff will be holding approval of corresponding Form 2s until the applicant provides, one, an approved pooling order, two, certifies that they have no unleased minerals in the unit to be pooled, or three, provide a voluntary pooling agreement. We understand that this is a big change to process, but we need to comply with the statute. So to assist with that timing, we are going to start allowing applicants to file pooling applications simultaneously with the corresponding OGDP and DSU applications. Next slide, please. Now, when I say simultaneously, I want to make some clarifications. I use that a bit liberally, and I would like to note that it's preferable that the pooling application is still filed after the OGDP and DSU application have been submitted and docketed so that it can be referenced in the pooling application. We asked that it's not filed as an exhibit to the OGDP DSU applications for a couple reasons. First, as I discussed in September, we are now noticing pooling applications for 90 days. Most OGDPs are now noticed for 60 days. We would like to avoid establishing two distinct petition periods within a single docketed application that has the potential in our minds to sow confusion among interested parties and could cause delays for one application if the other is petitioned. If these are filed all around at the same time, hearings will ensure that both are assigned to the same hearing officer for efficiency purposes. Okay. We briefly did discuss internally waiving the need to have document numbers listed within the pooling applications. We understand that that sometimes causes some issues with the pooling applications as they're waiting for the Form 2s to be filed or approved. We've decided that we would still like the pooling applications to require document numbers for the Form 2s to be pooled. So we just would like those to be tied to actual document numbers. It's pretty common practice for operators to file Form 2s as placeholders. So we would just ask that that process continue and then those document numbers be put into the pooling application. We'd just like that to be tied. We'd like the pooling applications and orders to be tied to distinct tracking numbers, not just well names, because well names are often changed after the fact. If document numbers change, the applicant can file supplemental testimony and or provide the new document numbers in a Rule 505E proposed order that they file with hearings. We'll make sure to update those as we process the matter. And if the document numbers change after approving of the pooling order, planning and permitting staff will work with applicants on a case-by-case basis to allow continued Form 2 review without the need for an additional application to amend the approved pooling order. So in short, applicants can file pooling applications now shortly after they've received a docket number for their OGDP DSU applications. We ask that you include document numbers that tie the Form 2s into the pooling application, and we can work with the operator on any changes that need to be made there. Following that will the pooling application and pooling order approval that will release the hold on the Form 2s, then those can move forward with approval in this situation. Next slide, please. I believe that's it for me. So I will be happy to answer questions at the end. Thank you.
Thank you so much, Elias. Next up, we have Corey. Corey, whenever you're ready, go ahead and take it away.
All right, good morning, everyone. I just have a quick update on the new Form 7. The updated release date for that is going to be December 2nd. We're currently in QA testing, so that is a realistic release date. We're going to make that. The Form 7 will be taken completely offline between November 25th and December 1st. It will not be available at all. The current Form 7 will be available through November 24th. Beginning December 2nd, it will be the new Form 7 with the updated templates. And an announcement with details will be posted on the website, and an email will go out to operators on the operator list when that happens. Again, access the form through eForms platform after December 2nd. Login credentials will be the same as you use for web forms. If you don't have login credentials currently, we will need a Form 1A designation of agent submitted so that we can get you set up with that. Once that's available, after you log in, click on Start a New Form, and you'll see the Form 7 available to you to file a new Form 7. Most common question I've been asked so far, yes, you will be able to submit multiple months and years. That is the same as the current web form version. Changes, there's no limit to the number of records. You can upload, I believe Chris tested it with 7,500 lines of data, and it did upload within 20 seconds. So we don't have a limit anymore. Business rules have been updated to ensure the quality of imported data. Validation has also changed. Data will be validated against our database during the time that you're importing instead of after it's submitted. So you'll see some additional errors come up, but I will detail that in the Form 7 guidance that will be released. We also have an improved delinquent report process that'll be coming in, so much more helpful than the current one. The new data templates are available now on the ECMC Form 7 webpage, and that does include the deep geothermal that is up now. Revised specifications for the well status and production template have also been posted. Specification information for the produced water and deep geothermal, along with more detailed guidance or updated guidance on the new Form 7 will be coming soon. And of course, as always, please feel free to contact me if you have any questions or concerns. Terry Eichenoy and Chris Eisinger will also be available to help with that. And that's it.
Thank you so much, Corey. If anyone has any questions, please put them into the chat. The first question is, in the new platform, will we be able to see the history of documents submitted?
Yes, I believe that will be in there.
All right, if no one has any additional questions, this concludes our operator meeting. Oh, one more just came in. Will we be able to see what other users within our company submit?
I believe you'll be able to see any documents that you would normally have access to.
Thank you so much, everyone. The video will be available within the next week. And again, thank you so much for attending our operator meeting and enjoy the rest of your Tuesday.